of the Commissioners for Her Majesty's Revenue and Customs and professional gain match official ability.
Yes, good morning.
Good morning, my Lord. I appear along with Mr. Pennell on behalf of the Revenue in this appeal. My learned friend Mr. Peacock is on behalf of PGMOL, leading Miss Georgia Hicks.
Yes, thank you.
My Lord, this is the Revenue's appeal against the Upper Tribunal's decision that the FTT did not err in law in concluding that the individual and overarching contracts did not have the necessary irreducible minimum mutuality of obligation to satisfy the ready-mix concrete Lim 1 requirement. You also have before you the respondent's notice challenging the Upper Tribunal's decision that the FTT did misdirect itself in law and took into account irrelevant considerations in concluding that the individual contract did not satisfy the RMC Lim 2 requirement of control. On all the issues, the Upper Tribunal has not substituted its own evaluative decision for that of the FTT, and therefore the primary focus of the appeal is on the FTT's decision, albeit that the Upper Tribunal's examination of the relevant Lim 1 and Lim 2 legal principles are more detailed, and therefore inevitably in this appeal we have to address both decisions.
Yes, I'm sure that must be right. And we have the guidance, don't we, from Lord Converse in the Pendragon case.
Exactly.
I always find it a bit difficult.
And
saying we have to concentrate on the Upper Tribunal, whereas in fact in a fact-sensitive case, that can't be right the whole time.
But in particular where in Pendragon the context was that the FTT, the Upper Tribunal, allowed an appeal from the FTT decision and substituted its own evaluative decision for that of the FTT. In those circumstances, one can see why
yes.
the court and the Supreme Court would say that the focus there is on the Upper Tribunal's decision. But that's not the case here. The Upper Tribunal has not substituted its own evaluative decision.
Yeah.
It has simply found that in respect of Lim 1, the FTT did not err in law, and in respect of Lim 2, it did err in law.
But the Upper Tribunal didn't find it necessary to redetermine the matter or indeed remit it because of the conclusion it had already reached on the other issue.
Exactly.
Yeah. Right.
So with that preliminary, my Lord, I propose to structure my submissions in 4 stages. First of all, I propose to take grounds 1 and 2 together. And so that is the RMC Lim 1 irreducible minimum principles and their application to the FTT's findings in relation to the individual engagements. Then I propose to address you on ground 3 and the overarching contract. Third, to address you on the respondent's notice, the issue of control, and then 4, to address you on disposal.
Yes. Can you just... We got a fairly generous 3 days allowed for this appeal. I don't know if you've agreed to timetable between yourselves or have any feel for how long we're actually likely to need. But.
So this was decided by Lord Justice Lewison on granting permission. He had canvassed with us whether it should be 2 or 3 days, as we had proposed. We pointed out that the Upper Tribunal decision itself analyses 35 authorities. And so, given that our appeal is that we say the Upper Tribunal in particular, but also the FTT, has fundamentally misunderstood the authorities, one has to go through the authorities, unfortunately, in some detail. We do say that it is on our case, we say this is a short point, but the FTT and Upper Tribunal, in their analysis, have overcomplicated the issue, and therefore to establish that, one has to go through the authorities to explain that.
Well, I understand that, and I'm certainly not wishing to hurry anyone up, because there's an awful lot of, I can call it in inverted commas, theology in this area, which we have to sort of get to grips with. On the other hand, it is sometimes easier to lose sight of the big picture when one gets too much engrossed in the authorities ploughing through decision after decision of the EAT. So I think we would be grateful for, if you can try and bring out the big points that matter most from your perspective, and of course, Mr. Peacock, do the same in due course.
Lord, yes.
And if we can finish in less than 3 days, that would certainly be good news as far as we're concerned, but we have the 3 days if we need them.
I understand.
Thank you.
My Lord, so grounds 1 and ground 2 relate to the Limb 1 ready-mix concrete test.
Yes.
As your Lordship know, in determining a status appeal, employment status appeal, notwithstanding when it was decided, the ready-mix concrete test is still the essential test. And that was common ground before the Upper Tribunal, and you'll see that at Upper Tribunal paragraph 10.
Yes, it's a curiosity in a way that a few sentences in the judgment of that antiquity still really form the whole basis of the law, as far as I can make out.
Exactly, and all of the cases always come back to that paragraph in the decision.
But we have to remember, it's not a statute. I mean, in fact, it's a decision of a first instance judge.
Quite.
A very expert one in the field.
Yes, albeit one endorsed.
And endorsed.
And endorsed all the way up to the Supreme Court as recently in AutoCleanse. I think it's paragraph 18 of the Supreme Court's judgment, Lord Clark's judgment in AutoCleanse, endorses that test. My Lord, can I ask you then to turn to tab 8 of the authorities bundle, that is ready mix. Ready mix itself is not an employment case in the sense that it's a national insurance contributions case. And it's a case that concerned whether concrete delivery drivers were engaged under a contract of service and therefore were employed persons for national insurance contributions purposes. Can I go straight to the test, which is at page 58 of the bundle pagination, 515C
yes.
of the internal pagination. And you'll see at the middle of the page, Ms. Justice McKenna says, I must now consider what is meant by a contract of service. A contract of service exists if these 3 conditions are fulfilled. 1, the servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. And that's obviously the first limb that we are concerned with. Second, he agrees expressly or impliedly that in the performance of that service he will be subject to the other's control in a sufficient degree. So you see the first reference there to sufficient degree to make that other master. And then 3, the other provisions of the contract are consistent with its being a contract of service. He goes on to say, I need to say a little about 1 and 2. As to 1, there must be a wage or other remuneration. Otherwise, there will be no consideration, and without consideration, no contract of any kind. So just pausing there, that's the first part. Mutuality gives you the contract. It's the consideration for the contract. Then, the servant must be obliged to provide his own work and skill. Freedom to do a job either by one's own hands or by another's is inconsistent with a contract of service, though a limited or occasional power of delegation may not be. So just pausing there, and then he goes on to 2, which is control. So just pausing there, those are the 2 elements of mutuality of obligation. 1, you're looking for mutual obligations so that there is a contract, and second, the servant must be obliged to provide his own work and skill. That's it. Then, if one comes to, in terms of mutuality of obligation, that's all this decision says about, judgment says about mutuality of obligation. As we're here, though, and to avoid me having to come back later, I'd just like to go through the way he addresses the second and third limb, because it also puts into context some of the submissions that you hear from the other side. As to 2, so this is still on the same page.
Yes.
But sorry, just before I do that, just pausing there, Your Lordship asked me about the case and having to go through all of the cases. In a nutshell, that's our case. And all of the authorities, when you come to look at mutuality of obligation, most of the authorities are looking at 2 things. That's why there is this vast sea of authority on mutuality of obligation. It's looking at mutuality of obligation in an overarching contract, so where there is no individual contract, and for employment rights protection purposes, in order to have continuity of service for unfair dismissal purposes, you need to bridge the gaps between the individual contracts so that you can say, I've got 2 years service or 1 year's service. And that's where you get into discussions about, well, okay, in the gaps, is there an obligation to offer or provide some work so that there is a contract continuing in the gaps? The second group of authorities are all about that second part, about is there a fettered or unfettered right of substitution? Because if you have an unfettered right of substitution, you have no obligation to do the work personally at all, because you can substitute the whole contract to someone else to do.
Yeah.
And that's all the cases right up to Pimlico, Smith and Pimlico Plumbers up to the Supreme Court, probably most recently.
But in relation to the overarching contract,
Yes.
I mean, potentially you can ask 2 questions about it, can't you? One, whether there's sufficient mutuality for it to be a contract at all. Because,
Yes.
I mean, every contract requires an agreement on one side to pay and an agreement
Yes.
on the other to do something.
Yes.
And whether that something makes it a contract, which is the second possibility, where it makes it a contract of service, depends on the factors that we can see set out here.
The 2 and 3, or the
Yeah.
But I would agree with one qualification. It's not enough that there is a contract. It must be a contract to do work personally. So, for example, if you look at the Kwashi case with the dancer, the reason why that failed on mutuality grounds was because the dancer did not contract with the club to work personally, leave aside personally, to work at all. She paid the club to use their premises.
Sure.
So whereas we don't have that issue here, because there's no question that this was a contract to work. And and that's what's often referred to as the work wage bargain. So it must be a contract, and it must be a contract to work in return for pay. Because if it isn't a contract to work, it will be a contract of some other kind.
Yes.
License being the most common.
I understand all that. I mean, that only gets one so far, because a work wage bargain can have one of 3 results: either that you're an employee, or that you're self-employed, or that you're a worker, for sort of where the statutes use that concept.
And that's why, and this is a critical point, ready-mix concrete isn't a one-stage test. That's the whole point of the 2nd and 3rd stages. All the first stage does is it gets you into the field, what Mr. Justice Elias describes in a later case as the field of employment, by which he says a contract of or for services. It's those other 2 tests that determine whether that contract is one of or for service.
I mean, that's where I'm having some difficulty with the rather, seems to me, if I may say so, rather rigid classification that you're inviting the court to adopt. I mean, why is it not possible, once you've got over that initial threshold, for one to look again at the question of mutuality in the context of the entire relationship between the parties, to help you decide which of the 3 types of work wage bargain we're dealing with?
So, first point, my lord, is that that's not this case. I think there's a case coming to the Court of Appeal next year where that issue arises. That's not what the FTT did in this case. It's not even what the Upper Tribunal did. the Upper Tribunal was clear that the issue in this case related to that first limb requirement. And the FTT found, so in order to get to the third stage, there has to be sufficient mutuality of obligation. And the FTT found that the revenue failed that first limb. The question about whether you can take it back into account at the third stage as part of the balancing exercise is a separate question. And there are authorities, but that's not this appeal. That's not what the tribunal did in this appeal. The FTT did, and it's not what the Upper Tribunal did either.
Well, I may have misunderstood things, but I thought the whole thrust of your first ground of appeal was to establish that, effectively, that the question of mutuality only goes to stage 1 and not to stages 2 and 3.
No. The FTT decided that we failed, that there wasn't the irreducible minimum mutuality of obligation.
Well, fine. I mean, if that's right, then you don't even cross the first hurdle.
And that's what they found. We didn't cross the first and second hurdles, even though at stage 3, the other terms pointed to a contract of employment. We didn't pass the first 2 stages.
Yeah.
So therefore, if they're wrong that before the Upper Tribunal, we appealed both of those. The Upper Tribunal found for us on limb 2. They found that they did misdirect themselves in saying there wasn't sufficient
on control.
Control. And on limb 1, the FTT said they didn't err. So if they did err on limb 1, we are left in the situation then where, on the FTT's decision, the stage 1 test is satisfied. There is mutuality of the irreducible minimum mutuality of obligation. You've then got the second issue about, well, is there a sufficient framework of control? Because the FTT didn't substitute their decision on that, although they found that they misdirected themselves.
Well, I know, Mr. Norbert, but I mean, I can see you're saying they were wrong to find that there was not sufficient mutuality of the relevant kind to get over the first stage. But I don't understand. We're talking now about the overarching contract.
No, sorry. Now we may be at cross purposes.
Oh, I see.
I'm talking about the individual engagement. Sorry, my lord, I thought we were talking about the individual engagement. Because on the overarching contract, all the FTT found was that there was no irreducible minimum, the necessary irreducible minimum obligation did not exist. So then they then moved on to the individual engagement.
Yeah.
In relation to the individual engagement, they find stage 1 and stage 2 is not satisfied. And stage 3, they say the other factors point to employment. So in the Upper Tribunal, as I say, limb 2 has gone. Their finding on limb 2 has gone. But the reason why the Upper Tribunal don't substitute their own decision is because they don't get past stage 1, you don't get past go. And that's the basis of the Upper Tribunal decision. Can I show you the Upper Tribunal decision where you see they define? Do you see it, paragraph 11? I don't know if you have it loose or in the bundle. In the core bundle.
You just tell us the paragraph number or the page define.
So it's page 83 of the electronic. It's of the internal of the bundle pagination. Page 3 of the decision.
Yes.
Do you see, having set out in paragraph 10 ready mix, they define the first element as the mutuality of obligation requirement.
Yes.
And then that's what they address thereafter. So, for example, do you see in paragraph 36? They say grounds 1 and 3. That's in the Court of Appeal grounds 2 and 3. both relate to the mutuality of obligation requirement, which they've defined earlier as RMC Lim 1. So, and I don't know if it's relevant to say so now, but in another case in which my learned friends are appearing, called Kickabout, where Miss Justice Zacaroli, who obviously was sitting here, where they sought permission to appeal the Kickabout decision on the basis that PGMOL was coming up to the Court of Appeal and would be addressing the third stage. Miss Justice Zacaroli, in the written decision refusing permission, was clear that PGMOL was about the first limb, RMC first limb. So that question about what, if any, weight mutuality of obligation has at the third stage did not and does not arise on the FTT's decision.
Well, I'm sorry, I may have misunderstood the thrust of your skeleton argument, and I certainly don't want to hold you up in developing the appeal as you want to, but I must say the impression I got from reading it was that you were concerned to establish the thesis before us that the question of mutuality of obligation is only relevant to stage one, and those considerations can't come in at any subsequent stage of the analysis. And that, I mean, if I've misunderstood that, I apologise, but I mean...
No. With respect, it's my learned friend's skeleton arguments that introduces, in reliance on Windle in particular, the issue of mutuality of obligation at the third stage.
Well,
but as I say, Windle is dealing with not mutuality within the engagement, but mutuality outside the individual engagement. If there is no mutuality outside the individual engagement, that is a factor that you can take into account at the third stage. Okay. But the reason why it's not our thesis, and I hope it's clear from our grounds.
Well, your grounds couldn't be less clear with respect. I mean, they just amount to a general bleat about everything the Upper Tribunal has done, without any particularity whatever.
Well, with respect, the grounds in my submission articulate the different ways using the Edwards and Bairstow formulation, because they all apply to what has occurred here.
I mean, normally to run an Edwards and Bairstow appeal, you have to satisfy the conditions set out in the Chippy case, you know, which you absolutely conspicuously have not done in this case.
Well, Lord, with respect, we say that they misdirected themselves in law as to the requirements of the first limb of the first stage.
Well, okay. Well, in that case,
because
I mean, is that the limit of your Edwards and Bairstow type attack on the decisions in that case? Misdirection of law.
Taking into account irrelevant consideration.
Yeah.
But that's important, my lord, because with respect, the irrelevant consideration here is the party's power to terminate at will.
Well, you'll have to tell us why that's irrelevant.
But similar, can I go through the authorities? Because, with respect, as we set out in our skeleton argument, that principle was established by the Court of Appeal in McMeechan, has been applied subsequently by the EAT in a number of cases, and also was recently applied by the Supreme Court in Uber.
But can I just be clear about this? Like Lord Justice Henderson, I mean, your various grounds of appeal don't give very much away in terms of what you're specifically complaining about. But is it right that 2 is attacking the treatment by the First and Upper Tribunal of the individual assignments?
Yes.
And 3 is also attacking, I think, their findings of lack of mutuality in relation to the overarching contract.
Yes.
So your appeal is a complaint, in part at least,
Yes.
that they haven't properly addressed these principles in relation to the overarching contract.
Yes.
And I thought it was part of that appeal, that ground 3, that you were saying that it wasn't relevant in relation to the overarching contract to consider mutuality as going beyond determining whether or not there was a contract at all.
No, sorry. So when I opened this before going to ReadyMix, I'm sorry if I didn't make it clear, but I thought I'd said that I was addressing grounds 1 and 2.
I know you were, but I mean, bearing in mind that the overarching contract is what they come to first, you thought you might go to that first.
Well, but with respect, the reason why in my submission I don't need to is because the individual contract.
No, I understand if they're contracts of service, then it doesn't matter whether
Exactly. Exactly.
Okay.
Then I can't look at the individual contracts separately, can you, from the umbrella or overarching contract under which they are made? I mean,
But with respect, that goes in two respects.
yeah.
One that goes in terms of when you look at the individual contract and what was the contract. But also, actually, when you come to the third stage, and your Lordship asked about the third stage, when you come to that third stage, the fact that there is an overarching contract, albeit not a contract of employment on the FTT's finding, the fact that there is a contract that subsists throughout the whole season with significant mutual obligations is a highly relevant factor. And you see that, and those factors are the tribunal does refer to when it's looking at the third stage. But Maura, I had understood your question to be about the quality of the mutuality within the engagement at the third stage. And it may be that I misunderstood the point.
Well, it's for you to explain your appeal as in the way it seems best to you, and I suspect the best thing now is to let you get on and do that.
Yeah.
And just perhaps bearing in mind our slight puzzlement on my part anyway as to quite why it should be necessary, if it is, to, as it were, shoehorn mutuality of obligation as being relevant only to the first element of a ready-mixed contract and ready-mixed concrete.
Well, as I say, for our purposes, I wasn't making any submissions on is it relevant at the third stage.
I see.
That's mutuality within the engagement.
Yeah.
But that's on the basis that in this decision, that's not what the FTT has done. The FTT has said there isn't the irreducible minimum mutuality of control, therefore, notwithstanding the other factors pointing in terms of employment, you don't get...
That's right. Well, if they were right about that, then
Yes.
their ultimate conclusion was correct and this appeal must fail. So,
Exactly.
yeah.
But that's why, so as I say, in the Upper Tribunal, I've already established they were wrong about 2. In that their finding that there wasn't sufficient control was based on a misdirection of law and took into account irrelevant considerations. That's the Upper Tribunal's finding. And they say we don't need to make that decision, we don't need to decide for ourselves whether there was that sufficient framework because you've not got past the first stage. Now, if I persuade your lordships that they were wrong to say that there wasn't sufficient mutuality for Lim 1,
In relation to the individual.
in relation to the absolutely, in relation to the individual contracts, well then there are 2 options. Either your lordships and ladyships substitute your own decision, or as I said, as I think would be my submission would be, as the Upper Tribunal said in respect of number 2, the matter goes back to the FTT.
Well, then the control issue becomes live.
But because the only reason it didn't become live in the Upper Tribunal, absolutely it becomes live. The only reason it didn't become live in the Upper Tribunal was because the Upper Tribunal found that they didn't err in finding that we didn't satisfy the Lim 1 requirement. But if I satisfy your lordships that in relation to the individual contract, they erred in finding that we didn't satisfy the Lim 1 contract, as I say, you're then in the situation whereby Limb 1 isn't satisfied. Limb 2, the Court of Appeal, the Upper Tribunal said they've misdirected themselves in law. Limb 3, well, we know they've said that that points to employment, but the matter, as I say, unless you're willing to substitute your own decision on control, then the matter would need to get remitted to the FTT. But my lords, that's why I take Limb 1 first. So that's why I'm taking the individual contracts first. Because if I'm right that on those individual contracts, the FTT erred in saying that the irreducible minimum mutuality of obligation did not exist, that means, as I say, Limb 1 is satisfied. So the first basis of the FTT's decision has gone. Control, we know, has already gone. And as I say, that at that stage, it's then a matter for your lordships and ladyship as to whether you want to embark on the evaluative exercise yourself, or, as my learned friends would invite you to do, or it gets remitted to the FTT. And on this basis, if you find for me on grounds 1 and 2, and it's really ground 2, you don't get to ground 3 in relation to the overarching contract. Because for tax purposes, as the court knows, the individual contract is sufficient.
Yes, because that's what, when the money is paid, which you want to tax. Or,
But it's also what the FTT recognised as well. Either contract would do. But my lord, that's why this issue about the third stage, does it come back in at the third stage? In my submission, doesn't.
Well, we wouldn't remit it back if, I mean, assuming you won on mutuality in relation to the individual contracts, whether it goes back or whether indeed at that part of the case has any further life would depend on what happened in relation to the overarching contract. Because if you were right, I mean, I haven't quite got my mind around how far your appeal goes on that, but if your ground 3 is right and there is a contract of service by dint of the overarching contract, well, one doesn't have to worry about the individual contract.
No, but I have to say that in respect of the overarching contract, ground 3 relates to the Limb 1 requirement of mutuality of obligation, the irreducible minimum.
Not for finding it wasn't
in respect,
a service contract.
Well, that puts you into the world of or for service. You've still got to satisfy the control test. Now, I can make the submission that on the findings, on the FTT's findings, they don't make a clear finding as to whether there is a sufficient framework of control in the overarching contract.
So that's all live as well.
That's all live as well.
Yeah.
Unless, I can point you to the various paragraphs where they themselves point to the features of control in the overarching contract, because they relate them back into the individual contract. But it doesn't feel like a function of the Court of Appeal. I can see that it would be a brave, and I'd be very happy to take on the challenge. But I would want. I'd be in the court's hands on that as to whether they were willing to embark on that exercise. But the point is that if, again, in relation to the overarching contract, if the tribunal was wrong on the irreducible minimum mutuality of obligation requirement, and that was the basis of their decision that wasn't a contract, they didn't go on to consider 2 and 3, then that matter goes back. Yeah. Does that answer your question?
Yes.
I say, I would like to say that there is a clear finding that there is a sufficient framework of control in the overarching contract, but the reality is the tribunal don't in terms express the issue of control or the third stage in relation to the overarching contract.
Right. So let's.
We were in ready mixed concrete.
Anything else we need to look at in ready mixed at this point?
Can I just take it quickly? As I say, I just want to avoid having to come back when we come back to the other grounds, particularly respondents' notice. In terms of control, you'll see that at 515G, I would say F to G, control includes the power of deciding the thing to be done, the way in which it shall be done, the means to be employed in doing it, the time when and the place where it shall be done. All these aspects of control must be considered in deciding whether the right exists in a sufficient degree to make one party the master and the other his servant. The right need not be unrestricted. And so what they're concerned with is the contractual right of control, not the practical exercise of it. And you see that from the top of the page, the top of the same page, you see Ms. Justice McKenna in the top line says, it is the right of control that matters, sorry, still page 515. It is the right of control that matters, not its exercise.
Yeah.
And then 516A, to find where the right resides, one must look first to the express terms of the contract, and if they deal fully with the matter, one may look no further. If the contract does not expressly provide which party shall have the right, the question must be answered in the ordinary way by implication. Then you get to 516B to G, and you'll see it says the third and negative condition is for my purpose the important one. So 2 points to note there. First is that, as the later authorities also say, that third condition is a negative condition. So you don't start the third stage from a neutral position. The second point to note is that in terms of ready mix, Mr. Justice McKenna identifies that in ready mix, for the purpose of ready mix, that third condition was what the case was about. 1 and 2 easily satisfied. And then he says, I shall try with the help of 5 examples to explain what I mean by provisions inconsistent with the nature of a contract of service. And that's important because the third stage is about inconsistency. If there is sufficient mutuality of obligation within the individual engagement to satisfy the first limb, how can it be inconsistent with a contract of service? In order to satisfy limb 1, there must be sufficient mutuality of obligation, sufficient for it to be a contract of employment. If it is sufficient to be a contract for mutuality to be a contract of employment, how can it be inconsistent with the contract being a contract of employment or of service? Then if one looks at the examples that Ms. Justice McKenna gives, a contract obliges, so remember, this is all in the context of the third stage. A contract obliges one party to build for the other, providing at his own expense the necessary plant and materials. At C, it's a building contract. It's not a contract to serve another for a wage, but a contract to produce a thing. So, contract to serve another for a wage. A contract obliges one party to carry another's goods, providing at his own expense everything needed for performance. And he says, not a contract of service, that's a contract of carriage. Contract 3, obliges the labourer to work for the builder, providing simple tools. That obligation to just provide simple tools, not inconsistent with the nature of a contract of service. So it's all about inconsistent. Or, contract obliges one party to work for the other, accepting his control and to provide his own transport. This is still a contract of service. The obligation to provide his own transport does not affect substance. And then at the bottom he says, I can put the point which I am making in other words. An obligation to do work, subject to the other party's control, is a necessary, though not always a sufficient, condition of a contract of service. If the provisions of the contract as a whole are inconsistent with its being a contract of service, it will be some other kind of contract, and the person doing the work will not be a servant. The judge's task is to classify the contract, a task like that of distinguishing contract of self from one of work and labour. He may, in performing it, take into account other matters beside control. The relevance of that last point is that up until this point, in the authorities, it had largely been thought, or had been thought by some, that control was the key issue. But just going back, just to the beginning of that paragraph, you see, an obligation to do work, subject to the other party's control, is a necessary, though not always a sufficient, condition of a contract of service. So that's the irreducible minimum. There must be an obligation to do work, subject to the other party's control. And the tribunal in our case found that wasn't satisfied. Then you get to bear in mind that the context of ready-mix concrete is an individual contract case because it's a Nick's case. So you're looking at when they, you're looking at the money they've earned. You're not needing to worry about the gaps in the gaps between their contracts. So that's that point. He then goes on to look at how the authorities have looked at that third condition. And I just take it very quickly, if I may. Sorry, I should have said that my friends in their skeleton at paragraph 6 rely on 517A, that paragraph I've just read to you. But the key point is that's addressing the third stage, as is ready-mix. Ready-mix, the focus of the ready-mix case is on the third limb. Sorry, could I then ask you to go to page 520G, that's internal pagination, bundle pagination 63. You'll see where the business on own account test comes, that you see in the authorities at the bottom of page 520, bottom, last 3 lines. If a man's activities have the character of a business, and if the business questions whether he is carrying on that business for himself or for another, it must be relevant to consider which of the two owns the assets, who bears the financial risks. If the man performing the service must provide the means of performance at his own expense and accept payment by results, he will own the assets, bear the risk, and be to that extent unlike the servant. So that's that business and own account test that we see. And you recall that in our case, the tribunal find that the referees were not in business on their own account. Then you see there's a case of US and Silk that's cited at C. I'll just take you to this because Ms. Justice Elias picks up this case and this example in one of the later authorities. These were coal workers who loaded and unloaded trucks. If you look at F, so there were 2 categories of workers in the Silk case. One was the unloaders, and that's the only one I'm going to take you to because that's the one that Elias J picks up later. You'll see he says, F, Silk sold coal by retail using the services of 2 classes of workers, unloaders and truck drivers. The unloaders moved the coal from railway vans into bins. They came to the yard when they wished, and they were given a wagon to unload and a place to put the coal. They provided their own tools and were paid so much per tonne for the coal they shifted. All the 9 judges held that these men were employees. And then do you see at G, about 4 lines in the quote, there are no option to gain or lose except from the work of their hands and these symptoms. That the unloaders did not work regularly is not significant. They did work in the course of the employer's trade or business. So the fact that there was no obligation outside the contract in that example didn't weigh heavily. Because they were found not to be in business on their own account, but working as part of the engager's business. Then if I could ask you to look at 525G, please. So I should say it's 525G. You see the point that is made about the common law test not to be restricted to the power of control over the manner of performance. Sorry, I'm on the wrong page.
Yeah.
525G. Sorry, this is the conclusion in Ms. Justice McKenna. But again, just to show you that this is a third stage, he's addressing the third stage. It's now time to state my conclusion, which is the rights conferred and the duties imposed by the contract between Latimer and the company are not such to make it one of service. It is a contract of carriage. And then do you see at B, 526B, these are obligations more consistent, I think, with a contract of carriage than one of service. The ownership of the assets, the chance of profit, and the risk of loss in the business of carriage are his and not the company's. So he's in business, and you'll see then at G. He is a small businessman and not a servant. So, because of the risks, financial risk, etc., Mr. Justice McKenna finds he's in business on his own account. So at that third, so although they pass the first and second stages, it fails the third stage. And I've shown you where he says in terms that it was the third stage of the test that was important for the purposes of this case. Can I ask you then to go to market investigations, which is at tab 9, page 87. And again, importantly, another national insurance contributions case. So again, another case where looking at individual engagements, where you don't need to establish continuity in the gaps between engagements. If one turns to bundle pagination 87, internal pagination 182D. The Lord's judgment of Mr. Justice Cook. So you'll see at D, the facts were that the individual was engaged from time to time to act as an interviewer for market survey purposes. The question was, whilst working under those engagements, was she engaged under a contract of service? Do you see that it's whilst working under those engagements? And just for your note, do you see at E, you've got the definition of an employed person? That's the one that was relevant for both ready-mix and this case. Then could I ask you please to turn to 182H. Do you see it identifies the sole issue for determination is whether she was employed during the relevant period under a series of contracts for services, or, as the Minister says, she was employed during the period under a series of contracts of service. So not an overarching contract case. 183C, you see he cites Ms. Justice McKenna. And do you see this? He says, with these and other recent decisions before me, I do not myself propose to embark on a lengthy review of the authorities. I begin by pointing out that the first condition which must be fulfilled in order that a contract may be classified as a contract of service is that stated by Mr. Justice McKenna, namely that A agrees that in consideration of some form of remuneration, he will provide his own work and skill in the performance of some service for B. And so, again, clear statement of, in an individual contract, what is required for the first stage, the first condition. But then importantly this, the fact that this condition is fulfilled is not, however, sufficient. Further terms must be applied to determine whether the nature and provisions of the contract as a whole are consistent or inconsistent with its being a contract of service. So again, this just goes to the point that, contrary to what is suggested by my learned friends, our submission as to the requirement of the first stage does not mean that everybody will be an employee. It is simply the gateway into the other conditions. And that's the point that Ms. Justice Cook is emphasising at C to D. Then, just for your note, at D to F, Mr. Justice Cook cites the Cassidy and Moran cases, which are the cases, the older cases, that talk about the limited benefit of control, where you're dealing with skilled or professional people. And that's the proposition is at F.
Yep.
And then if you see at 184, Mr. Justice Cook says, well, if control is not a decisive test, what then are the other considerations which are relevant? And you'll see he cites Lord Wright in Montreal. And can I just show you at E of the quotation from Lord Wright? You see that passage about business on own account? So this is page 184E. And then do you see the quotation from Lord Denning in Bank, part and parcel of the organisation, that you see in the later authorities, where it comes from? And then at G to H, Ms. Justice Cook says, the observations of Lord Wright, so that's business on own account that I've shown you, and Lord Justice Denning, that's part and parcel of the obligation. Sorry, part and parcel of the organisation. Thank you. And of the judge of the Supreme Court suggests that the fundamental test to be applied is this. Is the person who has engaged himself to perform these services performing them as a person in business on his own account? If the answer to that question is yes, then the contract is a contract for services. If the answer is no, then the contract is a contract of service. But what's clear is that it's that third stage which is the key for, which is critical for, to use the language of the Upper Tribunal, critical for delineating a contract of service from a contract for service. And then, so you see Mr. Justice Cook described that as the fundamental test. If you look then at 185, A to B, he says, the most that can be said is that control will no doubt always have to be considered, although it can no longer be regarded as the sole determining factor. And that factors which may be of importance are such matters as whether the man performing the services provides his own equipment, whether he hires his own helpers, what degree of financial risk he takes, what degree of responsibility for investment and management he has, and whether and how far he has an opportunity of profiting from sound management in the performance of his task. Then at C, he says, in the present case, it is clear that on each occasion on which Mrs. Irving engaged herself to act as an interviewer for a particular survey, she agreed with the company in consideration of a fixed remuneration to provide her own work and skill in the performance of a service for the company. I therefore proceed to ask myself two questions. First, whether the extent and degree of the control exercised by the company, if no other factors were taken into account, be consistent with her being employed under a contract of service. Second, whether when the contract is looked at as a whole, its nature and provisions are consistent or inconsistent with it being a contract of service, bearing in mind the general test I have adumbrated. And so that general test we know is the business on own account test, which he described as the fundamental test. And I say we know in our case the tribunal found not in business on own account. When they applied that test, they said not in business on own account. But be that as it may, the beginning of C is important though. Look at how, well, I'd ask the court to look at how Miss Justice Cook approaches, like Miss Justice McKenna approaches the first limb requirement of an irreducible minimum requirement in the context of an individual contract. In the present, it's clear that on each occasion on which she is engaged herself to act as an interviewer, she agreed with the company in consideration of a fixed remuneration to provide her own work and skill in the performance of a service for the company. So you've got a contract, and it's a contract to work. And it's a contract to work in exchange for remuneration, work-wage bargain. Again, just so I don't have to come back to this when I come to control, can I just take you to the control section of this decision, judgment?
Yes. But I mean, ultimately, your submission is, or will be, that the way the test is there formulated by Mr. Justice Cook provides a template that reads across very naturally to the present case. Is that right?
The findings in 159, and that's the critical point, that this tribunal, FTT, found that a bilateral contract was entered into on the Monday before the Saturday by a mutual exchange of promises. The offer is from the PGMOL offers the referee the work on the Saturday to officiate in exchange for a wage, for a fixed fee, and the referee undertakes, agrees, contracts to do so for the wage. That's it.
And that, you say, is sufficient mutuality.
Yes, because in this case there's no suggestion of, and the tribunal say there's no substitution, there's no right of substitution, you're contracting to do it personally.
Yes, you do have the right to back out, don't you?
Right.
I mean, that's the point you'll be coming to.
Quite, but as you see here, the critical point is that you're looking at the contract and what has been agreed. What have you contracted to do? And what the authorities go on to say is the fact, unless and until that contract is terminated, those mutual obligations subsist. That is why the fact that either party can terminate the contract and the terms in which they can terminate the contract doesn't matter. The critical point is there a contract or not? And can I just put it in context, just to, as you, Lords asked the question, just to put it in context. Important to understand the battlegrounds before the FTT. The battleground before the FTT was PGMOL's primary case, as you've seen from the decision, is that in fact there was no contract at all with the referees. And the FTT reject that. They say no. PGMOL itself had contracted to provide referees to the competitions. In order to satisfy their own contractual obligations to the competitions, they had to engage the referees, the services of the referees. So as I say, that primary argument rejected. Their secondary argument was that no contract came into existence until the referee turned up at the ground. The revenues argument was, no, a bilateral contract came into effect on the Monday constituted by the offer on the match officials administration system and the acceptance by the referee. And importantly, again, the FTT rejected PGMOL's obligation, PGMOL's argument that no contract came into existence until the Saturday when the referee attended the match. And the critical point about that is that the difference between us was, we says there was the obligation is on the Monday through the offer and acceptance. PGMOL was saying no obligation, therefore no contract until the referee arrives on the Saturday. Now leave aside how that works, where you've got 20-odd thousand spectators, TV broadcasters. On the Monday when the acceptance is done, the list is who's refereeing all the matches is sent to not just the clubs but the press. So all the programmes are published, what have you, and that's more a matter for, I suppose, the third stage for the overarching contract case. But on this point, as to is there that's why the battleground was there. They were saying no obligation, therefore no contract until the Saturday. We were saying no. The obligation to work is entered into on the Monday. Therefore contract on the Monday through acceptance of the offer of work. So I'm just trying to answer your Lordship's question to relate it back to our case. And that falls squarely within not just what Mr. Justice McKenna says, but also what Mr. Justice Cook says here.
Yes, no, thank you. I found that very helpful. I mean, I think that I'm now beginning to understand what it is you're. Sorry, it's my fault for being so. Is where it is what it is that you're really building. What it is you're finding here as your basic building block.
Exactly.
And I think that is it.
Yes.
I understand it.
It doesn't go much further than that, other than the termination cases, which show the relevance of a right to terminate.
Well, I quite see, and that's going to be critical, isn't it? Because if it
Yes.
weren't for the fact that on the FTT's findings, the referee could decide without breach of contract not to turn up because, for example, he had a last-minute business crisis in his day job, or on the other hand, in theory at any rate, the PGMOL, whatever you call them, they could decide to dispense with the referee services again without breach of contract if perhaps they got wind of some problem or other.
Yeah, no, and the examples were there. The examples of that was that risk factors were identified in terms of bias and so on. The referee had made an unfortunate tweet, I think was the example in the bundle. So because obviously the impartiality of the referee is critical.
Absolutely.
But importantly, that obviously applies. That applies not just to these referees, but also the referees who are employed. But for our purposes, though, and if I can make clear, we say it doesn't matter. All this point about did they have a right to terminate or not was an irrelevant consideration, even if they did have an unfettered right to terminate, either side. As the authorities show, an unfettered right to terminate, a right to terminate at will summarily, does not deprive the contract of the necessary mutuality unless and until the right is exercised. For so long as that right is not exercised, the relevant mutual obligations subsist. And of course, critically, because this is a tax case, in respect of all of the engagements that are subject to the tax and the NICs, that issue doesn't arise. Leaving aside the fact that it was very much a theoretical, that whole debate was quite theoretical, we say the short answer is it's irrelevant. You start with because when I take you to paragraph 159, I'll show you. At the beginning of 159, they find the bilateral contract and importantly what the bilateral obligations are. At the end, they then go on this discussion about the circumstance in which you can terminate, but then return to the fact, notwithstanding that, there is a bilateral contract at the beginning under which they contract to work in exchange for...
It's all turns, doesn't it, on whether you characterise the referee's ability to say, I'm not going, in fact, to referee this match, as the exercise of a contractual right to terminate, or simply him saying, I'm not going to enter into a contract.
And that's the critical. That's my point. Exactly. And I'll take you to two authorities where it's exactly like that. In that way, it's analysed. In one, the Edwards case, because that's that question about is there the obligation or not doesn't go to is there a sufficient obligation. It goes to whether or not there's an obligation at all so as to give rise to a contract. So there's a case in which, Edward's case, which is the booking case, where they say, well, when the relief worker accepts the booking, it's only an indication that they will work, that they can withdraw at any time, and the same on the engager. So therefore there is no contract until you accept by performance. And that's effectively was PGMOL. They didn't frame it in that language, but that was effectively PGMOL's argument in FTT, rejected by the FTT. So that is, Lord, with respect, that is the difference. The first question is there an obligation? If there is an obligation, then there is an obligation to work. And therefore, that's when, if there is a contract, then it becomes a right to terminate the engagement. But if you find there is no obligation, then you don't have a contract at all. And that finding is the tribunal's finding.
And the question of whether a contract is made when the referee sort of, at least at the first stage, accepts the bookings, if I can put it that way, or only when he actually turns up to referee, is that a question of fact or a question of law?
Well, it's based on findings of fact, because and the tribunal are finding that the tribunal have found that the level of commitment is sufficient to constitute contractual obligations. That's the critical point. And so this tribunal has found that this is not just an indication. They are entering into a contractual undertaking. Now, if they were going to find that it didn't reach that stage, then they would have had to have found that there was no contract. Then they would have accepted PGMOL's argument to say, actually, no, it's only on the Saturday. And interestingly, that's how the Upper Tribunal characterise the FTT's decision. They just say, oh, well, they must have found it was a unilateral contract. But as you'll note from PGMOL's skeleton, they don't seek to adopt that. They say that the Upper Tribunal have mischaracterised the FTT's finding, which was that it was a bilateral contract. And so the Upper Tribunal, with respect, have recognised the issue. Yeah. And that's why they've said, oh, well, it's a unilateral contract. But that is not what the FTT found. The FTT found that they entered into contractual obligations. And that's why, on the mutuality analysis, and this is what we said to the FTT, it's what we said to the Upper Tribunal, and what we're saying to the court, what we're submitting to the Court of Appeal, is that actually they should have stopped at 159 on mutuality of obligation, as Miss Justice McKenna, as Miss Justice Cook did. They should have stopped after the first 2 or 3 sentences in relation to the first NIM requirement. Moved on to control.
Would it be helpful if we just looked at 159 since you referred it?
Yes, of course.
Referred to it so much. It might help to make it all come alive a little more.
So, Lords, it's at page 39 of the internal pagination.
Yes, thank you. Yeah.
And can I just put it in context? Can I just show you 151, please, which is at page 37, just because, so you can, just to be clear, that they have found mutuality in the engagements. You see at 151, in concluding on the overarching contract, they say, it follows that whilst there were overarching contracts between PGMOL and national group referees in respect of each season, those contracts were not themselves contracts of service because there was no mutuality of obligation outside individual engagements. So implicit in that is that there is mutuality of obligation inside the individual engagements. And then you go to, sorry.
Yes.
Then everyone goes to 159, which is page 39. Do you see there's a heading? The individual engagements and mutuality.
Yes.
And again, just to follow that through, just so you can see the structure, if one turns to the top of 41, do you see its control?
Yeah.
And then at page 42, above 170, is the third condition. So no
Yes.
question but that they are applying the ready-mix test. Then, so just starting at 159. In our view, individual match appointments each gave rise to a contract constituted by the offer of the appointment made by PGMOL and its acceptance by the referee through the MOAS system. So, bilateral contract. Offer and acceptance. Under the contract, the referee would agree to officiate. So the referee is contracting to officiate, whether as referee or fourth official, and PGMOL would agree, so contracting, to pay fees and expenses at the specified rates subject to submission of a match report. Just pausing there, that is in the language of Mr. Justice McKenna, Mr. Justice Cook, the relevant mutuality of obligation. For a contract, you've got for the RMC Lim 1 requirement, you've got a contract, and it is a contract to work for pay or remuneration. Now, they then go on to say, and these contracts exist in the context of the overarching season-long contracts. Can I just make this point just while I'm here? That's significant in this case because only because when you come to hear the arguments about Windle and so on, all these cases that talk about the absence of mutuality being relevant during the individual engagement goes to the casual nature, the temporary nature of the engagement. But of course, this one isn't. The tribunal may not have found it was an overarching contract of employment, but they found it was an overarching contract with substantial mutual obligations between the two. But then, do you see, is where the tribunal, having done those made the finding of the bilateral contract, it goes on to talk about the circumstances in which either side could terminate.
Yes.
And then, do you see, it comes back to it though at the end, the last 4 lines over the page. Subject to these points, so those are the rights of termination. During the actual engagement, there would be some level of mutuality, namely for the referee to officiate as contemplated, unless he informed PGMOL that he could not. So that's the right to terminate. And see also the language of could not, but as I say, for our purposes, irrelevant. And for PGMOL to make payment for the work actually done. So at the beginning of 159, the end of 159, you have the sufficient, the clear findings on which the only permissible conclusion was that the RMC Lim 1 test, the irreducible minimum mutuality of obligation, was satisfied. They come back to it at 161. 160, they refer to Weight Watchers, which is, as I'll come to show you, is a substitution case. But interestingly, do you see this? They say, this is a case within Briggs J's third category. So Justice Briggs is talking about 3 types of cases. An individual contract case, an overarching contract case, and then a case where you have both. And so this is the one where you've got both. So he says, so it is sufficient, and I'll underline the word sufficient, because it shows that because that's the words they use in that final paragraph when they come to no sufficient mutuality or control. So it is sufficient for there to be mutuality, and here it's sufficient for the purposes of Lim 1 during each discrete contract for work done. However, and so this is where you see they start to go wrong, because you know they're saying you need to have sufficient, however, although not on all fours with the facts of Weight Watchers, well, not surprising, as we'll come on to see here, in many respects, Weight Watchers was a contract extending over a period of 12 months, where the leader would have to give a series of meetings, and it was to do with the right to substitute in those meetings. It is in our view relevant that the discrete contract started when an individual match appointment was offered and accepted, Now, just pause there. Again, that's a repetition of the findings in 159, that the contract, the bilateral contract, was formed based on contractual undertakings, offer and acceptance on the Monday. So what's the problem? It's that even after the acceptance, the referee had the ability to withdraw from the engagement before he arrived at the ground, and PGMOL was able to cancel the appointment. So it's the right to terminate. What's interesting here is actually this is a more limited right of termination than we see in the authorities. Often in the authorities, the right of termination is, you see a much more unfettered right of termination, which is that even halfway through performance or at any stage through performance, physical performance, either party can back out. Here, the tribunal don't go that far.
I mean, nobody suggests the referee could decide at half time he'd had enough and wanted to go home.
And that's exactly. So the tribunal have placed great weight on this right to terminate, but in fact it's a more limited right of termination than one sees in the authorities. But as I say, for the purposes of the Lim 1 requirement, it doesn't matter because it's irrelevant. Unless and until the contract is terminated, then those mutual obligations subsist. And you see that then in 162, where this authority was cited to the tribunal. You see they say a comparison can also be made with the facts of Cornwall County Council and Prater, where a teacher engaged under a series of individual contracts to teach unable to attend school was held to be, children unable to attend school was held to be employed. Each engagement in respect of a particular child being a contract of service, the teacher was committed, so here it's contractual commitment, to teach the child in question for the duration of the engagement for so long as was necessary. Mummery LJ said at 40, the important point is that once a contract was entered into, and while the contract continued, so until it's terminated, the teacher was under an obligation to teach the pupil, and the council was under an obligation to pay her for teaching the pupil. Well, how did the tribunal distinguish that? In this case, there is no comparable obligation outside the actual performance of duties at a match. Wholly inconsistent with their finding that a contract was entered into, contractual undertakings exchanged on the Monday.
The two cases that they refer to are firstly one where that's Weight Watchers, where they say that the right not to take the meeting was fettered in some way, so it wasn't an unconditional right to call it off. And the Cornwall case was one where there wasn't a right to call it off at all.
So in respect of Weight Watchers, the issue was the substitution clause.
Yeah.
Did you have a fettered or unfettered right to provide a substitute? Because if you have an unfettered right to provide a substitute, you have no obligation to perform the work personally. And what they've done there, this is where one sees the error, is they've transposed the language used in substitution cases. Is there an unfettered or a fettered right of substitution? They have incorrectly transposed that to a case in which there was no right to substitute, fettered or unfettered. So that's the problem with the Weight Watchers, reliance on Weight Watchers. The Prater issue is they misunderstood the point about committed. Again, the Prater case was about, did it pass the necessary threshold for a contract to be entered into?
But what are they actually, in these paragraphs that we've just been looking at, what are they actually saying? That there's, I'm not clear. I mean, they set out, obviously there are differences between the present case and the two cases that they refer to, but I'm not clear what conclusion they're drawing from it.
Well, I think the conclusion they appear to be drawing is that because of the right to terminate, that precluded the necessary minimum mutuality of obligation subsisting. And in doing so, they've relied on a substitution case, which as I say is dealing with, is there a right to perform the work personally? And they've misunderstood Prater. Prater, I mean, if you just take the paragraph that's cited in Prater, you would say that applies full square to our case. The fact they've misunderstood Prater is demonstrated by that last sentence where they say, in this case, there is no comparable obligation. But the whole point of what Prater is saying is, and that's the relevance of, and while the contract continued. So unless and until terminated, the obligations subsist. And interestingly, in Prater, the point was it wasn't clear when the contract would be terminated, or how long you'd be needed to teach the child. But so long as, unless and until it was terminated, the mutual obligation subsisted. And the point is that, and as you see from that quote, the important point is, where there's no issue about is there an obligation to work, the important point is at what point is the contract entered into? Because once the contract is entered into, the obligation subsists from that point up until it's terminated. And when they say no comparable obligation outside the actual performance of duties in a match, well, no, that's wrong, because they have found the comparable obligation. The comparable obligation is the obligation they have found in paragraphs 159, which is on the Monday, the individual referee contracts to referee on the Saturday in exchange for pay.
Yeah.
And to be clear, both Weight Watchers and Praters are limb 1 cases. So there can be no suggestion that the tribunal here is looking at a different limb. They're both limb 1 cases. Sorry, Mr. Pennell. Yeah, and Mr. Pennell makes the correct point that they're there looking at this. They've taken the reference to sufficiency as meaning some kind of weighing, or whereas it's actually about the existence of the relevant mutuality, and the finding that there is no comparable obligation, as I say, is not correct legally on their own findings.
So you say it's an error of law to say there's no mutuality merely because of the possibility that either side can back out of the contract without breach in probably very rare but nevertheless not negligible sort of circumstances.
And indeed, that's in our case, but it actually doesn't matter in what circumstance they can do. The point is, so I wouldn't say back out.
Well, all right.
Because once a contract is entered into, it's terminated.
Yes. Well,
I don't think I don't need to rely on that point. The point is, though, is that once the contract is entered into, the individual contracts to work, and the engager contracts to pay for the work.
So in a sense, the sort of Rubicon is crossed at the moment when you get a finding of a contract being made.
Unless there's any issue, as in the Quashi type case.
Yes.
About is it a contract for work?
I understand that.
Or
is it a contract at all?
Sorry, there's a third or. So the Quashi case is it a contract for work at all?
Yes.
The other option is the substitution, the Weight Watchers type.
Yeah.
Is it a contract for personal service?
But on that one, nobody's suggesting the referee can produce a substitute.
But it's a finding of it's
obvious.
It's in 159. 159, just above line 35.
Okay, well, if I need a finding, it's there. Yes.
But no right to substitute. The referee clearly had no right to substitute. The judge finds.
Yes. Right. Thank you.
Yeah. And then just to tie up the pieces, again, do you see? At 163, just this sufficient point. 163, in order for individual engagements to be contracts of employment, there must not only be mutuality but also a sufficient framework of control. So that's again where you get the sufficient from. And then you'll see at 174, insufficient mutuality of obligation and control in the individual engagements to amount to employment. And just to tie up that point, in their decision they do cite Montgomery, Court of Appeal in Montgomery, and if I just the language of Montgomery may be helpful here, just to see the tribunals, how the tribunal have approached this.
Sorry, where did we find that? I mean,
Sorry.
174 doesn't refer to Montgomery.
Yes,
That's-
sorry. So the reference I think is in paragraph 13 to Montgomery. I'll just well 163 is a reference to the sufficient framework is a reference to Montgomery, but it's also I think it's paragraph.
Oh, I see that.
Yes, paragraph 16 as well, and you'll see that in Montgomery, which is at tab 18 of the authorities bundle, and just the relevant test at the bottom of bundle page 223, last line. It's internal page 825, bundle page 223. If you just look at, if I could just ask you to look at the bottom line. You see, the bottom line says, it is though important that mutual obligation and control to a sufficient extent are first identified before looking at the whole. And so there's the sufficient. And that's what the tribunal have done. And you see the tribunal in 174, they've said, applying that, there isn't sufficient, the irreducible minimum, there isn't sufficient mutuality control. So even though at the third stage, the factors point to employment, it's not a contract of service. And also, as you're in 174, can I just ask you to look at, just because I was going to go back to market investigations briefly, just to look at the way they frame it at the end of 174.
Sorry, I'm lost now. 174 of what?
The FTT decision.
Of the FTT.
Apologies.
Yeah.
So, do you recall at the beginning of 174,
Yes.
our
Yes.
conclusion is that there was insufficient mutuality of obligation and control
Yes.
in the individual engagements to amount to employment, even though, and I say, so you can see they've said, and you've seen the reference I've given you in 23 about the irreducible minimum requiring sufficient mutuality and control. That was 23 of Montgomery. Then also, that's the first two lines of 174. But then do you see the last sentence? Our conclusion is that individual appointments to matches were engagements to perform the task of officiating at the matching question for a fee, and not contracts of service. Well, if one goes back to market investigations, you will see that that point it's made clear, tab 9 of the authorities bundle. I'll just find you it's internal page 186. And 91 of the authorities bundle. Do you see at the bottom of page? Do you see at the bottom of page 91, the last two lines? Mr. Payne for the company points first the fact that Mrs. Irving was appointed on each occasion to do a specific task at a fixed fee. So that's the language that the tribunal say. That's what these referees were appointed to do, not contracts of service. And if you look at 187B, as for the first factor, appointment to do a specific task at a fixed fee, I do not think that this is inconsistent with the contract being a contract of service. So just again a further pointer that the tribunal, in applying the test, in applying the principles, have misunderstood them. And there you have a clear self-misdirection. Because they've said that it's a it's not a contract of service, it's a contract to do a fixed task for a fixed fee. Exactly what that was the argument rejected by Mr. Justice Cook.
So in other words, it's a false opposition.
Exactly.
Yeah.
Lord, we've, as it were, whistled through almost our case on the FTT decision. What I propose to do now is just to go through the authorities to make good the sort of, obviously
So I mean, mutuality for these purposes, the first condition, the first RMC condition, it requires there to be a contract. And I suppose it requires it to be a contract which could either be a contract of service, in the sense that, does it? That in other words,
it could be a contract of awful services.
Yes, but if, for example, you could substitute, that would remove the condition of mutuality being satisfied.
So there's a long line of authority, of which Weight Watchers is part, which says that a right of substitution, it's sort of been watered down so that it's now the test is it a fettered or unfettered right of substitution? Get this right, a fettered right of substitution. So if you're, for example, if you're able to substitute, if you're unable, is consistent with a contract for personal service. But if you have an unfettered right of substitution, then that may be inconsistent with a contract for personal service, because you are not undertaking to do the work personally at all.
But my point is that if you I mean, clearly that's going down the contract for services route.
Yes.
But does that mean that it doesn't? I mean, you as I see the RMC, the way that they work is you're building blocks. You've got to say it's got to be first. There's got to be mutuality. Then there's got to be control. Then you've got to have a look at all the other terms of the contract.
You don't get beyond stage one. If it's an unfettered right of substitution, then it's not a contract for personal service, because you don't have to do the what you can perform the whole contract.
So well, that's
through
why
somebody else's hands.
Yes, no, I follow. So in other words, it's got to be a contract which does not contain a term that makes it impossible for it to be a contract of service for the mutuality, for personal service.
The key is personal service. Can I put one note of caution on that? It's not really relevant for our purposes, but I don't want to mislead you. That unfettered, fettered distinction, that was what Court of Appeal, Master Rolls, or Justice Etherton summarised the principles in a paragraph there, which I can take you to because I'm going to go to Pimlico Province later. But in the House of Lords watered it down even further and said, actually, you just look to see whether the dominant purpose of the contract is for personal service. So you don't get bogged down in, is it a fettered or unfettered right of, but are they really contracting for your services?
I mean, we don't need to go into that territory at all, do we? Because there's no dispute whatever. There's a finding of no right of substitution, and anyway, it's obvious that the referee has to turn up in person.
But it's relevant insofar as it shows the content of that first stage, so that
it's got to be a contract under which the individual concerned agrees for a fee that they will do the work or provide the service. Now it's personal. It's not to get somebody else to do it. It's personal. At that point, you satisfy the mutuality condition.
Yes.
of course, it doesn't determine of itself which of the two possible types of contract it is, but it satisfies the mutuality because it's capable of being a contract of personal service.
So in one of the later cases, James and Greenwich, Mr. Justice Elias puts it this way, that it locates the contract in the field of employment.
Yeah.
It's the other two tests that distinguish whether it's for or of employment or self-employment.
And so what I mean, just trying to understand what the FTT has done in the paragraphs you've shown us, they have said that the ability of the referees, because as Lord has said, I mean, there's not a power of substitution in this contract, whatever it may be. So that the ability for the referee basically to call the thing off, it means that there was never no. Sorry. This is what I'm having difficulty with. I mean, that they're not, I think, in terms saying there's no contract, but they're saying it's not a contract of the type that satisfies the mutuality condition. Is that what they're saying?
I think that's right, because with respect, when they say, because I think that must be why they say no comparable obligation. They don't say no obligation. They say no comparable obligation, which I think must be consistent with the fact that they have found that there is an obligation. They're just saying it's not of the right type.
Yeah. So
it's not sufficient.
Although they don't spell it out, they're treating it as the equivalent almost to a substitution case.
Yes, and that's the Weight Watchers.
Yeah.
The reliance on the Weight Watchers, exactly. Because you see, they get into the unable, unwilling, which is the language of the substitution cases.
Whereas you say they should have concentrated on the basic fact that this is a work wages exchange,
Exactly.
terminable in certain circumstances, but unless and until those circumstances materialize, you're just left with the basic obligations.
Yes, and that quote and it's encapsulated rather pithily in the paragraph the FTT themselves cite from Prater, which says exactly that. And you can see that was our submission, that we were the ones relying on Prater for that, precisely that point. So, that was 162 is the Prater quote.
Yeah.
FTT 162.
Yeah.
And this is where we get to the point where you've already got the Upper Tribunal's finding that they've misdirected themselves and took into account irrelevant considerations in relation to the control test. And you can see, I hope I'm demonstrating, they've done the same in relation to, because in control, they were focused on the fact that nobody could pull the referee off in the middle of a game. And so just as in relation to control they focused on irrelevant considerations, so in relation to the first limb stage of mutuality, they have focused on irrelevant considerations, misapplied the law in circumstances where, if they hadn't done, they have found that all the other pointers point towards employment, which of itself should be a telltale. That is not what one would expect. One would not expect to get to the third stage and find that the third stage is all pointing to employment. That in itself is a tell that something has gone wrong earlier. Sorry, I've got. And my lord, you were asking about the substitution cases. As I say, the effect of the substitution. It's about the nature of the obligation. So it's not about is there an obligation. It's the nature of the obligation. Is it a contract for you to do the? Are you contracting to do the work personally, or are you contracting to get the job done or the task done? And it doesn't matter whether, because if you can do the task whether by your own hands or by anybody else's hands, you're not contracting to provide personal service. You're contracting to get a task done. And so it's not that's not located in the field of employment or self-employment. Lord, can I go back to market investigations? Or are you happy for me to go back? I've sort of gone through the FTT decision.
Yes, no, I'm speaking for myself. I found it very helpful, actually, to look at the FTT in the light of your submissions, because I feel that it now all sort of coalesces in a way which I'm sure is my fault. It didn't when we started at 10:30. But it's really, if you think we need to go back to market investigations, do you want to go back to control now? I mean,
it was really the control paragraphs, and then I'm going on to the sort of 4 or 5 authorities that make good the termination point.
yes,
So,
well, obviously
directly,
I can see we'll need to look at those. And I think, I mean, just at a high level, I think you've just signalled on control, you will be making a similar point that the FTT really concentrated on the wrong target.
And obviously I've got the Upper Tribunal's decision, which accepted my submissions
On the existence of control.
Yes.
Yes.
but and the misdirection, but also that they misdirected themselves.
Yeah.
And what they didn't do is, because of the first stage, they didn't substitute their own decision.
Yeah.
That may be a matter for you, because, as I say, if I'm right about the first stage, then my submission that the point of on control is a short one, given the FTT's own findings, and you've got their findings on the 3rd stage.
Yes. Yes. So sorry. Let's right after quite a long excursion, shall we go back to market investigations? Is it?
Can I do this? Taking on board what you say about control.
Yes.
Can I come back to control? I'll come back to market investigations if I need to on control.
I think
and go straight onto the sort of the authorities that go to this issue.
I think it might be easier just to avoid us getting confusing the two subjects.
So can I go straight to the Court of Appeal in Meacham, please? And that is Volume A. Oh, sorry, Authorities Bundle, tab 13.
1-3.
1-3. Oh, sorry, I'm told it's 1-14.
No.
Apologies.
No.
14.
That looks better. Meacham.
And if it helps, just so you can see the path I'm going to trace through 3 or 4 cases that culminate in the Supreme Court in Uber, where they actually apply this analysis. And you'll see that they do so relying on 2 cases, McMeechan and Prater.
So this is Court of Appeal, yes.
Yes. You'll see, if I could ask you to go to page 551C just to pick up the facts. It's an individual engaged by an agency to work for an end user who claimed he was employed by the agency and sought unpaid wages. So,
sorry, where are you getting that from?
551C.
551, please, thank you. Yeah.
So he's a temporary worker who's effectively a wages claim, not an unfair dismissal claim, against the agency. So he's seeking to establish that he was employed by the agency through whom he worked for the end user.
Yes.
The importance of that is that because it's a wages claim and not an unfair dismissal claim, it was sufficient for him to be employed during the individual engagement. He didn't need to establish an overarching contract. But you see from 551E that he had pursued his claim before the ET and EAT, who was a litigant in person, on the basis of an overarching contract of employment. But before the Court of Appeal, he was permitted to advance the alternative single engagement basis, namely that he was entitled to be treated as an employee of the agency in respect of the single stint served with the particular client in respect of whom the monies claimed had been earned. Could I ask you to then go to page 553? Now, here they set out the contract between the agency, so the putative employer, and the individual. This is Lord Justice Waite. Interestingly, at G, do you see at clause 6, the contractor is not obliged to provide and you are not required to serve any particular number of hours during any day or week. In the event of your declining to accept any offer of work or failing to attend work, for any reason, at any period, this contract shall terminate. So just pausing there, it's not just if you decline to accept any offer of work, it's if you fail, having accepted the offer, you fail to attend for any reason, for any period, the contract shall terminate. Then there is this over the page at top A, and this is the clause that the Court of Appeal focus on. It's clause 10. The contractor, that's the agency may instruct you to end an assignment with a client at any time on summary notice to that effect without specifying any reasons. And that's the clause that they particularly focus on. So, termination at will. Summary termination. Anytime without specifying any reasons. Then 555H, please.
But 10 is the power of the alleged employer, i.e. the agency, to require the individual to cease working for the client. Yes?
Or to cease the engagement. So that would end the contract. Because we're here concerned with the individual, in the context of the individual engagement.
Sorry, I'm the only reason I'm asking is I just want to understand the alleged contract of employment was between the employment agency and the person who was on its books.
Yes.
When that person is assigned to a client of the agency, they presumably enter into a contract with the person to whom they're assigned. I mean, for example, if you hire
when you say they, do you mean the agency or the individual?
The individual.
No. So the way this works is you have an upper contract, a lower contract. You have the contract between the individual and the agency, and a separate contract between the agency and the end user. There is deliberately no contract between
That's
the individual.
what I wanted to be clear.
Sorry,
so that the worker doesn't become contracted in any way to the person who gets in touch with the agency. So we need somebody to do this or that.
And interestingly, and indeed, that's right. But I mean, there's no reason why it can't work the other way. I mean, often you see.
But you can have arrangements of that kind where the
individual
worker is simply provided to the organisation and enters into a contract with them.
You can do.
But you say that's unusual.
It depends on very much.
It
depends on the nature. But here, part of the reason for the tripartite arrangements is because the end user doesn't want any contractual relationship with the individual to avoid the risk of, or to avoid the burden of employment rights, etc., and to avoid the risk of employment claims, unfair dismissal, etc.
Yeah.
So there often expressly says in them there is no contract between you and the end user.
Yeah, and the end user pays the agency for the services that are provided.
And then typically then the contract with the individual and the agency, you get into arguments about, well, what's the control exercised by the agency, etc.
All right.
So yes, but here the reference to the contractor is the agency. The agency may instruct you to end an assignment with a client at any time on summary notice to that effect without specifying reasons. At 555H, they've referred to O'Kelly. Now, O'Kelly we'll come back to later because it's an overarching contract case, and there's also an individual. They deal with overarching and individual separately in the Court of Appeal. But you'll see here they're dealing there with the third limb. To consider all aspects of the relationship, no single factor being self-decisive. That's obviously the RMC third limb. The empiricism in that approach does not preclude recourse to familiar touchstones which have been found useful over the years. Harvey gives a useful summary of them. I do not in this judgment to mention more than one of them. It's usually referred to as the criterion of mutual obligation. The principle which it enshrines is that if there be an absence on the one side of any obligation to provide work and an absence on the other side of any obligation to do work, as may voluntarily be provided, then that provides a powerful pointer against the contract being one of service. Now that's the context of, that it's clear that this relates to the overarching contract. Bearing in mind that was what was argued initially. He goes on to deal with the individual contracts in the next paragraph. Temporary or casual workers pose a particular problem of their own. In that, in their case, there will frequently be two engagements, to use a neutral term, which the tribunal may be called upon to analyse. So in the previous passages dealing with the overarching contract, where there's just the question of an overarching contract, here you're talking about people who work under, it says there'll be two engagements, to use a neutral term, which the tribunal may be called upon to analyse. There is the general engagement, that's the overarching one on the one hand, under which sporadic tasks are performed by the one party at the behest of the other, and the specific engagement on the other hand, which begins and ends with performance of any one task. Each engagement is capable, according to its context, of giving rise to a contract of employment. This was acknowledged by the court in Netherlands. He then goes on at 556B, makes observation in relation to overarching contracts. So we know that he's defined the general engagement as the overarching one. This is the type of arrangement most frequently found in the authorities. The reason, no doubt, is that the temporary workers' single stints will seldom have been of sufficient length to found an independent claim in their own right for a redundancy or unfair dismissal. He then goes on to discuss Nethermere, which is itself an overarching contract case. Then can I ask you to look at 557C. This is important because, again, clear how, again, they're very careful, as you'll see in the later authorities, to distinguish between their consideration of the principles relating to overarching contracts and those relating to individual contracts. And you'll be aware that one of our criticisms of the Upper Tribunal's decision is that the Upper Tribunal said that the principles relating to overarching contracts are of general application and so apply to both overarching and individual contracts. Whereas, as you see as we go through the authorities, they're very careful, the courts are very careful to distinguish the principles that are applicable to either. Do you see this? The specific engagement. Less authority has been devoted to this topic, no doubt because there are normally fewer rights attaching to a single engagement. Then can I ask you to look at 562H. you see, probably actually it's best just to put it in context if one looks at E, just below D, just to put in context what he's addressing at H. It's as the argument proceeded, it appeared to the members of this court that the relief for which the applicant was really and primarily asking was to be treated as an employee of the contractor in respect of the stint he served with their client, Sutcliffe Catering. Lord Meston, who has been at pains throughout to ensure that the applicant suffers no disadvantage because he's a litigant in person. So you can see why the Court of Appeal were willing to allow the new argument to be advanced. He doesn't oppose the alternative case being advanced. He strenuously resists it on the basis that specific engagement cannot, as a matter of law, be severed in the way that it's proposed from the general engagement. And then do you see at H, if contrary to 1 and 2, so that's Lord Meston's 1 and 2, the individual stint is capable of giving rise at all to an independent contract of employment between the temporary worker and the contractor, the absence of mutual obligation to provide work or to do it is still relevant and fatally so for the purpose of construing the terms applicable to it. So that's number 3 of Lord Meston's submission. You'll see how that's dealt with then at 563G. Do you see, again, important that the heading, the single engagement claim, is it maintainable at all? And this is what they say. In a case like the present, where the money claimed is related to a single stint served for one individual client, it is logical to relate the claim to employment status to the particular job of work in respect of which payment is being sought. I note that the editors of Harvey appear to take a similar view, where they suggest at paragraph 853, the better view is not whether the casual worker is obliged to turn up for or do the work, but rather if he turns up for and does the work, whether he does so under a contract of service or for services. So if you found that there is a contract, don't get waylaid in is he obliged to turn up, but rather if he turns up and does the work, whether he does so under a contract of services or or for services. So that is 563 G. And then do you see at 564C, so in 564C, they're addressing the position as here, where the terms of the overarching agreement also apply to the individual agreement, and they're just discussing the challenges that can cause. The force of 2 is not lost in cases where, following what appears to be a common though potentially confusing practice, the agency and the temporary worker have committed themselves to standard terms and conditions which are intended to apply both to the general engagement and to the individual stints worked under it. The only result of that fusion is that the same conditions will have to be interpreted from a different perspective, according to whether they are being considered in the context of the general engagement or in the context of a single assignment. That does not make the task of the tribunals any easier and is liable to lead to the unsatisfactory consequence that the same condition may need to be given a different significance in the one context from that accorded to it in the other. Those disadvantages do not, however, supply any valid reason for denying the temporary worker or the contractor the right to have the issue of contractual status judged separately in the two contexts. In my submission, that is wholly inconsistent with the approach of the Upper Tribunal, that the same principles apply to this both in the same way to both contexts. Could I ask you then to turn to 564H, please? Again, I identifying the issue before the Court of Appeal is whether the individual assignments worked by the applicant as supplement caterers for a period of 4 days during January 1992, in respect of which he claims his unpaid remuneration did or did not amount to a contract of service in its own right. That is a question which, though it remains essentially one of fact and degree, is one which largely falls to be determined on the interpretation of the conditions. Those must, however, be construed according to the context afforded by a specific as opposed to a general engagement. So again, repeating the point that I've just cited to you on the previous page, emphasising the difference between the two. Now, in 1, 2, and 3 and 4, subs 1, 2, 3, 4, they set out their reasoning. Can I take you to 2? The conditions 3, 6, 9, and the first sentence of 5, excluding mutuality of obligation, are irrelevant in this context. Now, those were the ones that talked about outside the individual engagement, no obligation to offer or accept work. He says, that is not to say that in the different context of a general engagement, they would be without effect. They might there turn out to be of crucial, even decisive importance. In the circumstances of a specific engagement, however, there is nothing on which they can operate. When it comes to considering the terms of an individual, self-contained engagement, the fact that the parties are not obliged in future to offer or to accept another engagement with the same or a different client must be neither here nor there. Now, we'll come on to look at some of the later authorities where it said, well, that may be putting it a bit high. It may be a factor at the third stage, depending on the facts. Clearest one is Windle. But that's dealing with the third stage. 3, weighing the conditions in the way that the law requires, there is to be set on the one side contract for services, the express statement that the worker is to be regarded as self-employed and not to be working under a contract of service, and the liberty reserved to the worker of being able to work on a self-employed basis for a particular client. Now we know that the later authorities talk about labels not actually being particularly significant. Then this, on the other side, contract of service. So the factors he identifies as in favour of a contract of employment are to be set the reservation of a power of dismissal for conduct, and then this, the power of the contractor to bring any assignment to an end, and that is clause 10. So clause the agency's power to terminate at will that I took you to. Also, the provision of a review procedure if such termination takes place, the establishment of a grievance procedure, the importation referred to above of the stipulation of an hourly pay rate, so other factors. So the right to terminate the contract, here the right to terminate the contract at will, is simply a factor that goes into the mix at the third stage when you're carrying out the balancing exercise. And in this case, it's seen as the right of termination at will on the part of the employer is seen as being a pointer actually in favour of employment, not self-employment. And then do you see at 4, they say, when those indications are set against each other and the specific engagement is looked at as a whole in all its terms, the general impression which emerges is that the engagement involved in a single assignment gives rise, despite the label put on it by the parties, to a contract of service, employment, between the temporary worker and the contractor. So, in this case, not only is the termination doesn't get you past the RMC Lim 1 test, its only relevance is at the third stage, where it's one of clearly a number of factors that go into the mix. Now, obviously in our case, arguably you've got 2 both parties have the right to terminate. So you have an interesting argument about whether that makes them neutral. But the point is that irrespective, they are simply part of the, they are simply terms that go into the balancing exercise at stage RMC Lim 3. And so that is, as I say, Court of Appeal authority, that the right of a party to terminate the contract summarily at will does not deprive the contract of the RMC Lim 1 irreducible minimum mutuality obligation, so long as there is a contract, unless and until it's terminated, necessary mutual obligations exist. The termination provision is instead a factor that may be taken into account at Lim 3 stage. And just, again, I make the point that actually the termination provision here is far more extensive than in our case. Because on any view, the tribunal find that it doesn't extend throughout the engagement. It's up until the arrival at the ground. So it's a more limited form of provision. Moreover,
Well, it was more limited in one sense, but not in the sense that it was only the employer who had this right, not the employee.
but and then that's my point is that you might get into interesting arguments about there. But again, this is at the third stage. You get into arguments there about, well, if you've got one point, if you're doing the two columns, does one go in one column and one go in the other column? Do they count?
But an employee always has a right to terminate a contract of employment.
Yes, and as we'll see,
It's a factor which is consistent with the contract of employment.
it's consistent.
Yes.
Yeah. And you'll see that some of the authorities we come on to look more expressly at. So Stevenson, for example, is an obligation is an unfettered right on both sides. But as I say, and that Milady, that is the critical point, is that it's at that it's at that third stage that it only becomes relevant. And as I say, you can just a point I think I did make, but just in case I didn't, you can see what the tribunal has done here is they've conflated the two arguments. Is they've used the argument that they were advancing as to why the contract didn't start on the Saturday and fed it back into, having rejected it, they then sort of infected their reasoning, because they've then gone into this digression about circumstances in which you can terminate. Can I take you to a more recent encapsulation of these principles, not so much on termination, but just on that mutuality of obligation. It's auto cleanse. It's A tab 30. It's called Justice Aiken's in auto cleanse at paragraph 74. It's bundle page 399. So this is just Lord Justice Aiken, paragraph 74. Again, it's just to provide the court with a sort of hopefully a pithy encapsulation of the requirements. You see about 7 lines down, the ERA does not further define a contract of employment, and there is no other statutory definition of the expression. There have been numerous cases where judges have had to decide whether a person has entered into or works under a contract of employment. In essence, there are 4 basic requirements that must be fulfilled before it can be said there is a contract of employment, and so a relationship of employer and employee. First, the employer must have undertaken to provide the employee with work for pay. So what's the offer? Second, the employee must have undertaken to perform work for pay. Those obligations are mutual. The third requirement, and just pausing there, both satisfied on the Monday with the offer and acceptance of appointment. The third requirement is that the employee must have undertaken to perform the work personally. He is not entitled to subcontract the work to another. Just pausing there. Those are the elements of RMC Lim 1. Then this. Fourthly, it is also generally accepted that there is a further requirement before a court will hold that there is a contract of employment between employer and employee, i.e. that the employee agrees that he will be subject to the control of the employer to a certain minimum degree. These obligations have been described as the irreducible minimum to produce a contract of employment. So that's RMC Lim 2. What it doesn't refer to, of course, is Lim 3, but I think that's taken as a given because it's just talking about the irreducible minimum, stages 1 and 2. But just wanted to take you just there, just because, as I say, there, in my submission, rather neatly encapsulates the different elements.
This case did go to the Supreme Court, didn't it? Or
It did, but this is just Lord Justice Aitken's judgment is approved in the Supreme Court. But there, as you know, they go more into.
Well, I don't know actually, so we'll need to take a step
I
at
will,
some
no,
point.
it's very relevant to ground 3.
Okay, so we'll be looking at that at some point, will we?
Yes,
Yeah.
absolutely. But just in terms of the ready mix test, that's in terms of RMC Lim 1, hopefully a helpful.
Well, if you can give us the reference, maybe it's in your skeleton, I'm afraid perhaps it is, of where the Supreme Court actually approved this passage, that would be quite useful.
I will.
Perhaps over the adjournment, maybe you could find that reference for us. Thank you very much.
Then, can I ask you to go to Byrne Brothers, please, which is at A tab 20, please.
20.
20. So this is a building labourer's case. It's a worker status case where the Employment Tribunal has found that the absence of mutuality outside the individual engagements and the right to use a substitute negative the irreducible minimum requirement of mutuality of obligation in the individual engagements. So, absence of mutuality outside the individual engagements and the right to use a substitute negative the irreducible minimum requirement. Those were the ET's findings. If one turns to paragraph 6 of the judgment. So this, sorry, I should have said this is Mr. Recorder Underhill.
Was he then was?
As he then was. I think it might have been his first contribution to the scene. Statutory definition of worker. Worker means an individual who has entered into or works under a contract.
Where are we?
Sorry, paragraph 6 of the page 237 using the bundle pagination 670.
Thank you.
Paragraph 6 at D, just for the statutory definition.
Oh, I'm sorry, I got yes, with you. Yeah.
Statutory definition of worker. Worker means an individual who has entered into or works under a contract of employment, or B, any other contract whereby the individual undertakes to do or personally perform personally even any work or services for another party to the contract. If we look at 8.1, you'll see that it says the tribunal reasoning can be summarised as follows. They found that the subcontractors' agreement and the terms and conditions of engagement were binding on the applicants. And the tribunal found the EAT, however, observed it says the tribunal itself found as a fact that none of the applicants had read or understood the contractual documents, but the tribunal held each of the applicants is bound by the document he has signed. None were under any apprehension that it was a document that related to the work they were going to undertake for it. Recorder Underhill says that finding is not challenged. Clearly, however, those documents did not contain the entirety of the contractual terms. For example, the rate of pay is nowhere stated. And where they are silent, or their terms do not clearly deal with a particular area of obligation, it is necessary to go outside them. So just pausing there, the point of taking you to that is that he is making the point that this is a case in which all of the terms are not found in the contractual documents. So you've got to look at the contractual documents and elsewhere for the terms, and that's relevant for a point I'll come on to. At sub 8.2, you'll see the ET's finding. As a conclusion of the majority, the majority was expressed as follows: the terms of the agreement which the applicants entered into meant that although they worked on a day-to-day basis, they did so under an agreement which excluded any possibility of the mutuality of obligation and permitted the use of a substitute worker. The majority of the tribunal find that the lack of mutuality of obligations in the subcontractor's agreement meant that none of the applicants can be an employee. And Mr. Recorder Underhill says that he infers that the reference to the combined effects of clause 10 and 11, that's the absence of, is an absent, the no obligation to provide and no obligation to accept work clause. You'll see at paragraph 9, Mr. Justice Underhill identifies 4 issues. And you'll see that although mutuality of obligation was argued together with personal service, he says that in addressing the issues, he separates them out. So one is personal service. Did the applicants undertake under the contracts under which they work personally to perform work or services? Then business undertaking. And you see, it says in practice this turns on the effect of clause 13. So again, it's these construing these substitution clauses. 2 is business undertaking. 3 is mutuality of obligation. Mr. Stafford contends that the relationship constituted by the terms and conditions was one under which there was no mutuality of obligation. Although he advances submission as part of the submission in relation to personal service, it seems to us that it is in fact a distinct point. Then you see at paragraph 10, he says, the issue is whether the contracts under which each of the applicants worked oblige them to do or perform personally any work or services for the contractors. We are therefore concerned with the construction of the contracts under which the applicants worked. So far as this issue is concerned, the relevant terms are to be found in the subcontractor's agreement and the terms and conditions of engagement referred to in it. On ordinary principles, those documents must be construed in the light of all the relevant circumstances, but subject to that, we are concerned simply with the construction of those documents. The issue is accordingly one of law. So where you have a contract which is made up where some of the terms are found in the written contractual documentation, some of the terms are found elsewhere, where you are construing the written documentation, that remains a question of law. And that was why I took you to that earlier paragraph where he made clear that in this case, it was a case where all of the terms were not just found in the written documentation, it was also found elsewhere. That's relevant when we come on to construe the code of practice in this case. Can I then ask you to turn to paragraph 13? And this is only just to show you that although he's considering personal service in the context of worker, he's applying ready-mix concrete, and you see that in paragraph 13. We reach the conclusion in the first instance without reference to the authorities relating to the requirement of an obligation of personal service in a contract of employment. However, we do not believe that it could be right to adopt a different approach in considering the requirement of personal service implicit under Lim A, and that explicitly stated in Lim B. The authorities relating to contract of employment are thus plainly relevant, and then cites ready-mix concrete. Then could I ask you to go to paragraph 24?
Sorry, where?
24.
24.
So it's page 680, and it's paragraph 24. Bundle pagination 247. So it's tab 20.
I'm afraid mine gives. Oh yes, no, I'm sorry. I have got it. Yeah.
Thank you. Paragraph 24. Do you see that paragraph 24? So this is under the heading mutuality of obligation.
Yeah.
And if you look at paragraph 24, you'll see Mrs. Stafford submitted that the contract comprised by the subcontractor's agreement and the terms of engagement gave rise to no mutuality of obligation. He drew attention in particular to clauses 1, 10, 11 and 14, which for convenience we set out. And you see that the first conditions, the first ones are the no obligation ones, no obligation to provide or accept. But 14 is the contractor and the subcontractor shall be entitled to terminate this agreement forthwith and without notice. So the engager's argument was, well, look, there's no mutuality of obligation because 1, there's no mutuality outside the engagements, and 2, both parties are entitled to terminate the contract at will. Do you see at 25? We accept that mutuality of obligation is a necessary element in a Lim B contract, as well as in a contract of employment. So they're applying the same test. The basis of the requirement of mutuality is not peculiar to contracts of employment. It arises as part of the general law of contract. But in our view, that does not assist the contractors. Then you go to paragraph 25. But just before we do that, again, it's important in this context that when they're talking about, it goes to whether there's a contract or not. The word work, in these cases, the work-wage bargain is a given because it's clearly a contract for work in return for pay. So the key issue is you then, so that's why they talk about these points about contract. Then you go to 25, sorry, we've done 25, then at 26, so they reject the argument about the gaps because you can have because here you could have a single individual engagement. So there were no gaps here, so they didn't need to worry about an overarching contract. That's 25. But 26 is the one relevant for our purposes. So he says that deals with Stafford's submission based on 10 and 11, insofar as he makes a separate point on clause 14, which provides that the contract can be terminated without notice on either side. We do not believe there is anything in this point. A contract is nonetheless a contract so long as it subsists, even though it may be terminated forthwith by either party. Lord, I wonder whether that's the... That one is. That one's not much help. It's just 5 to 1. I was about to go to Stevenson and Delphi Diesel, but I was going to suggest that perhaps I do it after lunch.
Stevenson is
Tab 21.
just the next tab, is it? Yes, and that is a
Mr. Justice Elias.
Right.
So that these are the two cases that the Upper Tribunal relied on.
Yes.
Sorry, they said there was that one was contradicted by the other.
Yeah, so we relied on Mr. Justice Elias and Stevenson,
And they said
and they say
says something
they
different.
said Cotswold says something different.
Yeah.
Which I can come on to, but the important point is that the principles that I'll take you to in Stevenson about terminable at will, as I hope I've demonstrated already, not only does Cotswold not say something different, but it doesn't matter, because I've shown you Byrne Brothers, but more importantly, I've shown you the Court of Appeal in McMeechan, and as I'll show you further, it's then you've got Prater, but you've then also got Uber in the Supreme Court that applies that.
So in a way, this is all a build-up to Uber, which you say is anyway the last word and obviously the highest, so to speak, word on the subject.
Exactly.
So.
Exactly.
Yes.
Yes. But and then when I got to Uber, I was then going to go to a decision, but I've done that already.
Yes. Well, I think I think it was helpful to go to the decision at an early stage, because that helps to focus the points you're making.
Thank you for directing
Well,
me there.
anyway, that's what we've done, and I've certainly found it useful. So, yes, well, now is a good moment to break, I think. So we'll continue at 2 o'clock. Thank you very much.
Thank you.
I noticed everybody took their masks off. You're actually supposed to keep them on unless you're speaking. It's actually a rule of the court, and like the judges have agreed to it. So unless you're speaking, you're not really supposed to keep them on. I know it's difficult.